to Pretty Lies and Alibis. Join us as we seek the truth and travel the long road to justice. Hi, everybody. Happy Friday, Alibiers. Welcome to another episode of Pretty Lies and Alibis. I'm GiGi, flying solo, hopefully for the last day. Looks like Fruit Loops had a blast in Dollywood, scooting around on her little knee scooter / motorized scooter. And we'll be back together on Monday, thank goodness, because I hate being alone. I have realized that. All right, before we get started, shout out to one of our amazing sponsors, Too Cool T-Shirt Quilts. You can go to toocooltshirtquilts.com/prettyliesandalibis. Check them out. We really appreciate their support. And I have to give a big thank you to Lori Hellis, who surprised me and really touched my heart a couple of days ago. I got a package from UPS, and Miss Hellis had sent the most beautiful wind chime in remembrance of my Aunt Angie. And little did she know, Angie and I had exchanged wind chimes several times at Christmases and birthdays in the past. And I can hear it. It's right outside my studio. It's been singing all morning, and just a very thoughtful gift. I had the honor of spending some time with Miss Hellis out in Vegas a few weeks ago, and she is kind and gracious and generous, and just really appreciate that gesture so much. All right, so moving on to the big news. Lori's trial is moving to January. They're going to have a couples trial, 2 for 1, which I think is great for a lot of reasons, mainly the family. They don't have to sit through this twice. Once is going to be hard enough. And also the prosecution, the defense, the witnesses, everybody does this once. You know, if she had gone to trial in October with a 10-week trial, it would have given everybody just a couple of weeks over the holidays to reset and do it all again. It makes the most sense for a lot of reasons, but it's a little risky, I think. Look, I think that Lori maybe I'm way off, but I think maybe she set this up to where no matter which way this fell, she had a reason to appeal. If she had went in October and loses, like we all believe she will, was she going to come back and appeal on ineffective counsel? Even though essentially she tied some hands behind their back, now probably can assume she will at least try to appeal being moved up to January. We will see. Scott Reich said, we will see. We'll just have to wait. So the ruling was 12 pages. And in the beginning of the ruling, he said that in Barker versus Wingo, the right of a speedy trial is necessarily relative. It's consistent with delays and depends upon circumstances. It secures rights to a defendant. It does not preclude the rights of public justices. So he goes on to say a fact-specific inquiry is necessary to assess the particular context for any case where a delay has or is anticipated to frustrate an individual's right to a speedy trial in order to determine whether good cause exists. Whether there was an infringement of Clark's statutory right to a speedy trial presents a mixed question of law and fact. So in State versus Clark, it says good cause means there is a substantial reason that rises to the level of a legal excuse for the delay. Because there is not a filed rule for determining good cause for the delay of a trial, the matter is initially left to the discretion of the trial court. Where there is good cause for the failure to try the accused within the 6-month period, the delay is generally doesn't violate the accused speedy trial rights. Finally, the state bears the burden to demonstrate good cause for a failure to bring a defendant to trial within the 6-month limit. And that, again, is State versus Clark. So what did they argue? The state argued good cause exists in this case to extend the 6-month limitation for Lori's trial, urging the court to schedule the trial concurrently with Chad's in January of 2023. And the court must decide whether doing so is justified by good cause that would not deprive the defendant of her constitutional and speedy trial rights. So it says the court considered the mixed question of fact and law in determining if the state has demonstrated by substantial and competent evidence that the delay here is warranted. So we know the indictment was timely filed and there was a delay in her arraignment because she had a stay in her case of being incompetent. The court considers whether that delay violated the code, which requires a trial within 6 months from the date the information is filed, if the trial has not been postponed by application of the defendant. So it says Idaho code creates an exception when a defendant's trial is postponed by their own application. Defendant's attorney of record filed a request for the court to order Lori to go undergo a mental health evaluation in a related case prior to the filing of the indictment in the instant case. And we all know on June 9th of last year, she was found incompetent and was committed to the Idaho Department of Health and Welfare for restorative treatment and halting the proceedings in her case completely. And that's the other thing is if you think about all the motions that Pryor has brought before Judge Boyce since Lori has been incompetent, there's going to be a lot of hearings, even with it being in January, for Lori coming up throughout the summer, the fall, and through the winter. I think they got a lot of catch up to do, not to mention the mountains of discovery clearly that's in this case. So the court determines that due to the required stay of the case, there is substantial and competent evidence that the exception to the rule applies, as the delay before arraignment was through no action of the court of the state or the state, rather as a direct consequence if the determination that defendant was not fit to proceed to trial. So it says here the period of time Lori spent committed to the custody of the Department of Health and Welfare is told for purposes of calculating speedy trial timing as it relates to her arraignment date. We know she was found competent April 11th, and she was arraigned on April the 19th. And the timing for speedy trial with that is October 19th. And we mentioned before, ironically, that is going to be the anniversary, the 3-year anniversary of the date that Tammy Daybell was murdered. So the court will apply Barker versus Wingo factors to determine whether there is good cause to delay Lori's trial. And there are 4 factors that he used. Number 1 is the length of the delay. So it's 82 days from the 6-month deadline for speedy trial, 90 days from the current trial setting. So it's not like you're looking at 6 months, 8 months, a year. You're looking at 82 days from the 6-month deadline. I think that is going to be something that, if this goes to appeal, that might be a really good argument that, it's not like we're delaying her a year. Until there is some delay that is prejudicial, it is unnecessary to inquire about the 3 other factors. The length of the delay is a triggering mechanism for further analysis. They consider the complexity of the case and seriousness of the charges in granting the state's motion. So number 2 is the reason for the delay in the 4 factors. The Barker factor they consider is the reason for the delay. The court recognizes the pretrial delay is often inevitable and wholly justifiable for reasons such as the parties need time to collect witnesses or oppose pretrial motions. The judge will weigh if the state is deliberately trying to delay the trial to hamper the defense. And they also weigh less heavily negligence or overcrowded courts. And so when she was deemed incompetent and they extended that stay for treatment, they're saying that cannot be overlooked and assessing the delay from the date the indictment was filed to present. After she was restored, the delay between the arraignment and trial date must be scrutinized. And we said that's October 19th and January 9th to decide if there's good cause to delay her trial. So he goes on to say the state argues improper severance since Lori and Chad were named together in that indictment. And the court, as we know, said that they are properly joined for trial. They denied Chad's motion to sever these cases. And he mentions that her defense team was only recently assembled, and her attorney has indicated they need time to prepare a full defense on her behalf. They're charged with the most serious crimes and are alleged to have co-conspired to commit murder. And the state has filed its notice of intent to seek death penalty in both cases. There are also allegations of a conspiracy to commit multiple financial crimes. The conspiracy allegations were the basis for the court's decision to deny a severance for Chad. The court has been advised of the extraordinary volume of discovery, and Lori's attorneys have expressed their concern about not having adequate time to prepare for an October trial, although they have in no way argued against her assertion of her speedy trial rights. And like I said at the last hearing, I don't know Archibald. I haven't watched him enough to really gauge body language and stuff. I did sense a little bit of frustration with him of, yeah, we told her and she still wants her speedy trial. We know the amount that we got between the Chandler document dumps and the Gilbert document dumps. It took us weeks to really go through just those two documents. You're not talking about DNA. You're not talking about what all other probably terabytes of digital evidence they have. I'm sure that they have a lot of stuff they have yet to even scratch the surface on. So I totally get Archibald in that. They also say that advancing Chad's trial from January to October could deprive his necessary time to prepare for trial since it's been scheduled and his attorney has relied on this date to prepare. All of these factors weigh in favor of a legal excuse for a delay. The third thing they consider is the defendant's assertion of their rights. And she did for a speedy trial. She wanted it. Number four, prejudice to the defendant. So they assess a few things when looking at this: preventing oppressive pretrial incarceration. Number two, minimize anxiety and concern of the accused, which has not been argued by the defense, and her attorneys have acknowledged her mental state is fragile and complex, but she has been able to cooperate with the preparation of her defense, and this factor is neutral in this assessment. Number three, limit the possibility the defense will be impaired, which is the most serious form of prejudice because of the inability of the defendant to adequately prepare their defense. It skews the fairness of the entire system. So Judge Boyce says Archibald has only recently been appointed, and even more recent after the arraignment was the appointment of co-counsel. And due to the large volume of discovery, the court finds continuing the trial will not result in an impairment of the defense of the case, and it would allow them additional time to prepare for trial. In addition, the seeking of the death penalty complicates the defense's preparation, and there's been no argument a delay would impair their ability to defend her case. This weighs in favor of the state to delay her trial. And with the trial set for 10 weeks, it confirms the scope of evidence the state intends to introduce. The court is concerned the defense may be impaired by being required to go to trial in October, and moving Chad to October could prejudice his defense. So there you go. That's where that prejudice weighs in. And, I wonder if Judge Boyce really just looked and said, okay, out of the two of them, if one appeals, which one's likely to win? Maybe with Chad, with it being prejudicial to his defense. And then you've got Lori, who was committed for a very long time. And maybe he felt an appeals court would side with Chad, and then you got to do this trial again. So I'm not super convinced this is a terrible decision. I think either way he's going to have an appeal, whether it was Chad or Lori. You just pick your poison and run with it. So the court determines good cause exists to move her trial to January, and her constitutional rights are not violated by extending the time for her trial by an additional 82 days. And I think there we go. That's what it is. And we will see, the wording of that previous filing that her mental health is fragile and complex worries me that maybe at some point she goes incompetent again. And then we're back to, Chad's got a trial and that's it. But who knows, guys? I just wanted to read this. I know a lot of our listeners actually don't have social media, don't know about the filings, kind of just reading sentences, but there it is. Be interesting to see what happens. And also, let's see here. I forgot to put it on here. Let me pull up these dates. We did get some dates for Lori today. She is going to be having the pretrial conference for her is scheduled, I assume maybe for Chad, I don't know. But for Lori, November 9th at 9:30 in the morning is going to be that final pretrial conference before this goes to trial. And then, as we know, the trial is currently scheduled for January 9th through March 17th of next year. Busy stuff coming up with this case, guys. We're on it. Also looking for updates about Caitlin Armstrong. They really haven't said much. Who knows where she's at now? I did read where her boyfriend Colin has left the state of Texas out of fear that she may come back and do the same to him. So anyways, that's it. I hope you guys have an amazing weekend. We will be back on Monday unless something crazy happens over the weekend, and you guys enjoy it. No, Monday is Memorial Day. So happy Memorial Day is a relative term. Just want to say that we are grateful to all of those brave men and women who have made the ultimate sacrifice for this country, true heroes, and it's not lost on us while we grill out and have a day off on Monday. So, all right. See you guys soon.